It's my pleasure to welcome you to the annual Red Flag Seminar. This is the third year that's being co-hosted by Dave Pitney, Breard Associates CPAs, and Regulatory Maven. Now, today's program, as you can see on the agenda here, will consist of an individual presentation offered by Kevin Breard, which is always very interesting because it's kind of a state of the industry presentation. And then we have two panel discussions with very brief breaks in between. But the purpose of this program is to provide an update on the status of the broker-dealer/RIA industry and the key regulatory issues affecting it. It may be more than that, but that's the central focus. And I'm ready to introduce our first speaker today, Kevin Breard. He was a CPA and managing partner of Breard Associates. The firm specializes in broker-dealer audits and related and RIA audits and related regulatory matters. Welcome, Kevin Breard.
Good morning. Pleasure to see everybody here today. As many people in the audience have seen my presentations before, I'll have about 25 minutes and we'll go through about 60 slides. So I'll be moving. You probably could pay attention to the screens in front of you. I do want you to enjoy this presentation. As most of my presentations, I like to start off with a quote. A handful of patience is worth more than a bushel of brains. Today I'm going to cover 7 areas. The first area, what does the broker-dealer landscape look like? What new rules bring up big fines for RIAs? Oh, by the way, in the audience, who are broker-dealers? And who are RIAs, Registered Investment Advisors? Oh, excellent. Okay, so I'll know how to speak to the audience. Number 3, why can't my auditor be more helpful with my financial statement preparation? Fair value. And in New York City, what asset has plummeted by as much as 40% within the last year? Sleep, a competitive tool? When politics and taxes cross paths, what does the future hold? So I like to do an overview of the industry. I like to take a look at the numbers. I like to take a look at where the big fines are. And of course, the poster boys or girls that make the news. So let me ask you, and maybe one day I'll use Poll Daddy where you actually will be using your phone. But let me ask you, number of broker-dealers as of December 31st, according to FINRA, in round numbers. Do we have 6,400, 5,800, 4,700, 4,100, or 3,500? What do you think? All right, I hear some grumbling. That's good. we got 4,100. So, by the way, if you get the right answer, you get a free ticket to next year's complimentary seminar. As of September 30th, we had about 4,020. In a 4-year period, if I was going to use 2010 as my base, what does it look like in terms of FINRA membership? I have the exact numbers and the rounded numbers. I'll use the bottom row, the rounded numbers. You can see 4,600, 4,500, the troops are decreasing, 4,300, 4,100, 4K. Looks like a bunny slope if you were a skier, a little slight slope. It's decreasing every year. And a large reason for that is FINRA expelling firms, suspending firms, and a number of individuals. And as you can see in enforcement actions, in terms of individuals, it's not a couple hundred. I mean, you know, one is barred, 500, one is suspended, 700. These are big numbers. So, let me ask you this. What is the total of FINRA fines assessed during 2014 in millions? 22, 86, 110, 135, or 270? What do you think? Without looking at the slides before. All right, here's some good numbers out there. The answer is 135. But let me put that in perspective. And this is from FINRA. Look where we were in 2008. Can I say a paltry 28 million? Can I say that? And look where you are in 2014, 135 million. 2013, 60, so it's doubled. It's doubled. What about oops, and why? Why have they increased so much? I think they borrowed a term from the fast food industry. They supersize fees. In 2014, you have 25 cases where you get assessments over $1 million. That's going to grab your attention. In 2013, you only had about a dozen. Restitution. Restitution in 2014, $52 million. In 2010, $10 million. 4 times. So when I look at your industry and what you're working in, I don't think your hands are being slapped anymore. I think they're being whacked. And you need firms like Dennis's to keep you in compliance, and of course Liza and Hank here, they pit me because the landscape is changing. In homage to Dave Letterman, and not doing a 10 countdown, but just the five top things that got firms in trouble in 2014. Number five, trade reporting. You have about 11.1 million, the prior year 12.1 million. Cases about the same, but these numbers are going to ratchet up. Number 4, anti-money laundering. Broker-dealers, you need to have it, and RIAs, stay tuned, because I'll be talking about that. 13.2 million, 5.4 million the year before. Best execution, 14 million. You've got 83 cases, almost double the prior year. In second place, advertising. And I know as FINRA members, you can have a whole day of just going through advertising and all the cases. My purpose is just to make you aware of where advertising falls. Penalty, 17.2 million. And number 1, research, analysis, and research reports. 59 million. The prior year, only 1 million. And just as a comment here, a previous top 5 winner that didn't make the list this year was suitability. There's been a decrease in infractions, but you know, in 2012 it was the gold medal winner, 2008 and 2012 silver medal winner, so it's always been up there in the rankings. One war story that I would like to share with you, in the applications that FINRA reviews when they look at our clients, one of our clients at least twice said that someone's liquid net worth was greater than their total net worth. If you don't quite understand that, you can see me afterwards and I can talk about it because it doesn't make sense. Poster boy for bad broker dealer. Latour Trading, New York based. Flash boy, high frequency trader. Lacked minimum capital 19 months out of 24 months. My suggestion is maybe 5 months they were in net capital by accident. And hey, how much were they out of net capital by? 2 million to 28 million. And here's the thing that really scares me. They were 9% of the trading activities. And when you talk about counterparty risk, that's pretty scary. 16 million in penalties were handed down. What did they do wrong? For the FinOps in the audience, they didn't take the proper haircuts. They failed to take haircuts of proprietary positions. That's overrated. Didn't take the proper minimum capital charges on future positions. And we had computer errors, and somehow, no haircuts were taken. So that's going to help your net capital if you just don't take any of those haircuts. The other thing they did, which really scares us as auditors, is another entity, a related party, paid a lot of the broker-dealer bills. And that's something that we as auditors probably won't find unless we're auditing the other entity. Thought I'd like to take a look just at some of the highlights of exaggerated claims and misleading market scripts. I will kind of read this word by word. Most of my slides I won't, but this I will. So the first example, the company stock is a 10-bagger the next 12 to 24 months. And 10-bagger, as you know, is one of those neat terms you have in the securities industry. Peter Lynch, one up on Wall Street. This is a company with huge investment potential and arguably the most impressive list of investors of any company I've ever seen. Now that will get you in trouble. As hot as this company is, it really doesn't matter because you have 6 months put at a 50% profit. And the last one, guaranteeing a backstop. We are extremely confident, not just confident, but extremely confident that there will be a substantial demand for the stock in 6 months. The stock will be worth more than $60 million in 6 months. But if we are wrong, we have the wherewithal to buy it ourselves, which we will do. Exaggerating claims. All right, RIAs. What new rules rang up big fines for RIAs? Pay to play. Pay to play. Came in 2010, you can see the SEC reference. And this prohibits campaign contribution for advisory business, directly or indirectly, any kind of payments to government officials, and we have a firm in Philly that violated that. And simply what happened is the advisor gave fees, or campaign contributions, I should say, to the governor and the mayor. You might as well cover your bases both locally and nationally, or statewide, right? And they were able to link campaign contributions to pension work on the city and state level. They were able to link this through the audit trail. So what ended up happening is you had $300,000 in disgorgements, penalties, and prejudgment interest. That's a bad day at the office. I'd like to comment just briefly on areas where I see RIAs continually getting in trouble, and this could almost be the same slide every year. The first thing is misappropriation of personal use. I think 20% of CNBC's American Greed is on registered investment advisors misusing assets of the client. This next one is very serious. I've had some personal experience with the SEC in this. Diverting from a strategy listed in the fund prospect. So you had a strategy, whatever that strategy is, and now you have a different strategy. Don't do that, or communicate it to the client. That has got our at least 2 clients in trouble with the SEC. Misleading performance advertisement. And the last one, which I've spoken on extensively in the past, that I won't speak on today too much, is that custody. If a registered investment advisor has custody, and I won't talk about how they'll get custody, but they are in a position of custody, they're failing to undergo a surprise exam or issue audited financial statements. One of my favorite topics, and it usually comes across more like, why can't my audit be more helpful with financial statement preparation? You always used to be able to do this. Yeah, well, times have changed. Just in a one sentence, James Doughty at PCAOB, Public Company Accounting Oversight Board. Auditor independence is fundamental to audit quality. We have to have independence. And to that extent, there's been a number of CPA firms that have not had independence. Some of these firms have been our competitors. Here's the SEC rule reference. So auditors cannot be involved in any types of books or record keeping or preparation of financial statements or sending financial statements to the SEC. Cannot do it. And if the firm is not independent, the broker-dealer is violation of the Exchange Act, and the CPA firm has engaged in improper professional conduct. And technically, the audit should be redone if the auditor is not independent, although I have not seen that happen. But the SEC has found problems with the auditor. And this is, the first list came out in December of 2014. Cease and desist orders, pretty serious. Some censures, requiring firms that audit broker-dealers to actually have some training. And about 20 firms were hit with this, and that's pretty significant. There's probably about 800 firms in the United States that audit broker-dealers, and having 20 of them hit is pretty significant. And the fines, $140,000 in fines, and one CPA firm, $55,000. As I gave you an overview of the industry, and other speakers will give you an overview of the registered investment advisor industry, but for the broker-dealers, the number of broker-dealer audits, number of broker or dealer audits per firm. So there's some firms out there, and I'll show you a pie chart. There are some firms out there that only audit one broker-dealer. Only audit one broker-dealer. And when the PCAOB comes in and they find, is there any problems with a one audit, a one-off, there's a 100% problem. A 100% problem. And areas of problems, 50%. If you're 2 to 20, problems with your audit, 95%. 43% of the areas observed. 21 to 50, 94%, or excuse me, 90% and 41% of the areas observed. And you can see it all trickle on down. If you're doing 51 to 100, you're still finding 94% problem with those audits in 39% of the areas. And the last area, more than 100, and I'm proud to say we're one of those firms that do more than 100. 2/3 of the time they're finding problems. So even though everyone thinks they have the easiest audit in the world, the amount of documentation required by PCAOB, and I have to be honest with you, because I deal with them on a first name basis, some of the forms I'm working for, I'm only working for PCAOB, I'm not working for the benefit of my client. This doesn't make your audit any better for me to be doing these procedures. And here's the pie chart. So, in terms of broker-dealer audits, the number of firms that audit just one broker-dealer, one-offs, 43%. That's huge. I don't know if any of you would go to a doctor who only did one operation a year. And some of you know that. Some of you have to explain to the auditors every year what your business is. Of course, you have to explain it to FINRA too. But I just wanted to show you what that's all about. You can see the pie. We're that 1% yellow up there on the top. All right, fair value, one of my favorite topics. And what asset has really plummeted here within the last year? Well, fair value is a big deal. Big deal. PCAOB has it on their list. It's number 3. I know inquiring minds would want to know what the other ones are. I won't go into details with them, but the first thing is the revenue recognition, reliance on records, fair value, financial statement preparation, disclosure, and the last one is the customer protection. That's what's happened within the last year. Uber, that's what's happened. So technology has really taken over here, and the cabbies have really had a problem. You've had some medallions that were worth more than 1.3 million before Uber came in. And now they're only worth maybe 700,000, 800,000, or maybe there's too many zeros up there in the last number. Some people are nodding yes. Montauk Credit Union, seized by regulators in September of 2015, just a couple months ago. 178 billion institution is unsafe and unsound because they're holding medallions. And these medallions have gone down in value. The credit union sued New York City for failing to protect the cabbies. The Queens judge ruled against the credit union. And that's happened in other cities too. It's also interesting to know that some of the medallions were 100% financed. What could go wrong? For valuation, for registered investment advisors, avoid cost values. Avoid cost values. Think of cost as a dirty 4-letter word. There could be some exceptions where you could use cost, but I'd rather not go to the exceptions. From my experience working with the SEC, they really believe the registered investment advisor is not doing his homework if he can't get off the cost of value. And of course, I understand, and it's a robust discussion, that there's an internal conflict with registered investment advisors and asset values, because the higher the asset value, the higher their fee. So there's that internal conflict. But you have to know you've got to be more aggressive and not as passive in some of these investments. One of my favorite topics, and hopefully you haven't used this presentation for this, is sleep a competitive tool? Is sleep a competitive tool? Well, 1 of every 3 of you probably got less than 7 hours of sleep last night. I won't ask you to raise your hands. But what ends up happening is insufficient sleep gets you to obesity, high blood pressure, diabetes, poor work performance, car accidents. And one Harvard research estimates that, almost 2 weeks of work are left. So what does this mean to you? Well, I think maybe you've heard of this broker-dealer, Goldman Sachs. They're using sleep experts. And what they're finding is some digits are helping people. And other companies are doing this too. And Google is one of them, just to make you aware of what's out there in the marketplace. One of my favorite topics. when politics and taxes cross paths. There is a belief, often by politicians, that the capital markets are really just too focused on short-term results every quarter. And you know, if you want to grow America, the idea is you got to leave your money in a place and let it grow, and you shouldn't be jumping around. And so what better way to change someone's behavior than to accomplish it through the capital gains taxes? And there is a candidate running for office that has this proposal. We'll talk about that at the end. The capital gain process right now is pretty straightforward. It's a binary system. Short-term, long-term. Short-term, less than a year. Long-term, more than a year. Everybody wants long-term taxes because it has a very low rate. Long-term taxes are at 20%. That's desirable. Whereas the ordinary rates can crank up close to 40%. But let's change the definition of short-term so that it more than doubles. That way people are not switching in and out of stocks. And the benefits of long-term will have to go to 6 years, like a Senator of the United States term. 6 years to get long-term benefits. And in between 2 years and 6 years, there'll be kind of this rate that will phase out until finally you get to the desirable rate after 6 years. It's just amazing to think that far in the future. This slide just kind of summarizes what I just said. You know, less than 2 years, short-term, the short-term capital rates will get pounded at ordinary rates. Ordinary rates are bad, ordinary rates are high. And where this will apply is for the high earners. And just to help you on high earners, single about $413,000, married about $464,000. That too will get affected. They had a similar proposal from FDR many years ago. Does anybody have any idea, without looking at the slides, whose proposal this was? Hillary. Exactly. Now whether you'll see this, I don't know. Again, I think there could be a robust discussion of what this might mean to broker-dealers in terms of wrap fees, in terms of how you make your money, ticket charges, commissions. I mean, it's interesting what may happen, but I can talk about this for sure in the future and what's going to happen, and I'll be wrapping my presentation up with the future. There's the Office of the Investor Advocate, maybe a new name to you, sired by Dodd-Frank in 2010. Only took 4 years to find someone to head it up. Not bad. And when they finally headed it up, they actually have objectives that they come out with. And there are 6 core areas they're going to look at in the coming year. I'm only going to cover 3 of the 6. First one, affecting everybody here, broker-dealers, fiduciary duty. Accredited investors, they want to make some changes. And the trade settlement cycle. Fiduciary duty, in about 10 words, a registered investment advisor has a client's best interest at heart, kind of loyalty and care, that's where they fit on the spectrum. Broker-dealer has a different set of fiduciary obligations. They have more of a suitability and more of a deal fairly. I've talked about this extensively in the past, but just wanted you to get an idea where it is. And with these 2 different standards, well, that inequity between the broker-dealers and the registered investment advisor, well, that confuses the investors and confuses the retail public. And if it confuses the public, it's got to get the attention of the lawmakers, because they'll make it better. And this has the support of Mary Jo White. And what the SEC is seeking to the investment office here is a uniformity or harmonization of fiduciary care. And the level they may go to is the RIA level. And Rick Fleming, who heads this up, says this is their task, to develop a standard for broker-dealers, no less stringent than the existing standard for investment advisors, while accommodating sales-based compensation and sale of proprietary products or limited product lines. So quite a straddle. Investment Advisor Committee, definition of an accredited investment advisor, as you know, income single, over 200,000, married, 300,000. You need to have a net worth of greater than $1 million, excluding your residence. And they want to tinker with this definition. They even want to tinker with it that, what does income levels have to do with sophistication? Maybe what has to happen here is you should be taking a test. And the other thing is, I think it's a lot of our audience, or in terms of audits, of what we do is private placements. Private placements. They've got a proposal that maybe the limit of your investment in a private offering to a percentage of your income or a percentage of your total assets. They want to limit it. The other area they want to tinker with is shortening the trade cycle. We've got T+3. They're looking for T+1. Some of you in the audience are old enough to know T+5. Proposal. FinCEN, we're always talking in acronyms, but it's the Financial Crimes Enforcement Network. RIAs need to adopt an AML, and this will be a third time they've tried it, but maybe this third time will work. They want the investment advisors to be like a financial institution, and that means you've got to file the SARs, suspicious activity reports. And by the way, if a suspicious activity report is ever filed on you, you will not know. CTRs are currency transaction reports, anything greater than $10,000. Well, at this point here, I'd like to conclude my presentation with Lord of the Rings, and I'm not talking about Tolkien's books. I'm talking about Phil Jackson, where he said, yes, victory is sweet, but it doesn't necessarily make life easier the next season, or even the next day. How level-headed is that for a man that has 11 rings? Thank you for your attention.
The coming presentation is being offered by Dave Pitney partners Bob Appleton and Dave Elliott as they discuss current important insider trading issues. Bob, who just flew in from Sweden for this presentation, advises a diverse range of corporate clients on compliance matters, while Dave chairs the firm's Shareholders and Securities Litigation Practice Group.
Thank you very much for coming, and as just indicated, please feel free to ask questions during the presentation. We don't have a lot of time. I'm sure all of you have heard the term and heard the phrase and understand the concept of insider trading. It's a deep and significant topic, one which we could spend all day on, but we have just 20 minutes. So what I hope to do is focus on what's happened recently in a major shift in the law on insider trading. So what is insider trading? Well, I'm sure many of you most likely realize and understand that insider trading has never been defined by Congress. There is no statute that prohibits insider trading. Insider trading has been criminalized or prohibited by the courts over the years, starting from the Securities and Exchange Act of 1934, and it's evolved through court decisions ever since. What is it? Well, typically it's essentially basically trading on material, non-public, inside information that the average investor doesn't have. And both the SEC and the DOJ both enforce insider trading laws and the insider trading provisions, and equally as energetically. Typically, as I'm sure you know and or have heard and have seen, the insider trading cases principally evolve around trading in advance of earnings releases or mergers and acquisitions, where information is tipped to an outsider who then trades on it. It's important to understand that both the person inside, the tipper, as well as the tippee, are potentially responsible and liable for trading on material non-public information if that is established. In December of 2014, the world of insider trading was flipped essentially upside down with a decision in a case called U.S. versus Newman, which occurred right here in New York in the Southern District and then in the Court of Appeals. And up till that point, from 2009 to 2014, the Southern District U.S. Attorney's Office had been extremely successful in insider trading cases prosecuting 96 cases and winning all but 5. Since the Newman decision, they have dismissed 14 cases as a result of the Newman decision. So this is the principal topic of today's focus of today's presentation, to talk about what is essentially the remote tippees. It's when information passes down the line to further and further recipients, and the government's attempt to hold those recipients way down the line liable for insider trading when they get in possession of material non-public information and then trade on it. There are 2 basic concepts or theories for insider trading. One is classic, which is the typical insider getting information, passing it to an outsider and trading on it. The other is the misappropriation theory, which is where a person who owes a duty of loyalty to the organization or to the entity then violates that duty by passing information. For example, a lawyer or an accountant who work in the company or with the company and then pass information that they receive or learn about. So the government in these remote tippee cases are principally focused on brokers, traders, and insiders. And what has essentially been the law up till Newman was that basically it had 3 elements. First, that the tipper breached the duty of loyalty to the company by providing the information. 2, the tippee had a reason to know that the information was improperly obtained. And then 3, the tippee used that information by trading on it. Well, after Newman, the government or the courts have required the government to prove 2 additional very important and very significant things. First, that the tippee, the recipient of the information, was aware of the breach of the inside information, that the insider had breached a duty and disclosed the information, and then B, more importantly, that he received, or he or she received, what's called a material personal benefit from disclosing the information. And so those 2 requirements now have to be proven by the government when they go after insider trading cases in any case, and especially we'll talk a lot about personal benefit, because the personal benefit piece applies to all insider trading cases, not just remote tippee cases. So, as we said, the tipper, the person providing the information, needs to breach the duty when he or she discloses the information, and has to receive some benefit from doing that. This has been the law for some time, where the breach and the duty is really the essence of the crime, and the courts have always held that that breach needs to be proven by the government. So after Newman, everything changed. So we should probably talk a minute about the Newman decision. In Newman, it was a case where the confidential earnings data originated with a Dell employee who had tipped the earnings numbers not yet released to Wall Street analysts, who then in turn passed it on to others, reaching 2 traders, third and fourth hand, who then traded and benefited quite substantially from the information and the trades. They ended up going to trial and were convicted. They then challenged the conviction on appeal, challenging the government's case, basically saying that they did not know the circumstances of how and who the information was passed, and also that there was no evidence that the insiders actually received any benefit. And so the government's theory of trial was, well, they were friends, and the general career advice that was provided, or the reason why the information was provided was in exchange for general career advice. The courts held that wasn't enough. So the court has said, at least in the Second Circuit, and we'll talk about how that applies throughout the country, said that just merely being friends is not enough of a quid pro quo, or not enough of a benefit in order to achieve liability. And then first it holds the government must prove that the defendant traded on inside information, knew that the insider disclosed the information and received a benefit. And 2, that the benefit must be more than friendship and career advice. And what the court said, I think equally unhelpfully, was that it had to be, quote, objective and consequential, whatever that means. And that is something that now the courts are struggling with that definition as we go forward. The case, although it only was in the Second Circuit case, the government took an appeal. The Supreme Court just recently declined to hear the case, which means the law, at least in this circuit, is the law in the Second Circuit. Now, the Second Circuit is where most of these cases arise, obviously because we're here, Wall Street is here, and the wealth of economic activity is all here. But these cases are brought elsewhere, and there have been other cases that have perhaps reached inconsistent results, including the Payne case, which was in Boston, which we'll discuss in a minute, which the government had argued was inconsistent with Newman, and had argued that was the principal argument for why the Supreme Court should hear it. The Supreme Court disagreed, didn't hear the case, so here we are. So after Newman, what's happened? This is now about 11 months old. The landscape has drastically changed. The government, as a result, has dropped 14 cases where they were pending at the time the Newman case was decided, and has vacated convictions on others. So, what has happened? One case that, so I'll go through a couple of cases that, to give you some examples. In the Onyx pharmaceutical case, in that case, two individuals challenged the court or the SEC that were relying on Newman, where they were accused of purchasing Onyx in the days leading up to a report by the Financial Post in Canada that Amgen had proposed to buy the company. The judge actually denied the motion to dismiss the case, even though the SEC doesn't know the tipper. So, in another case, we'll talk about in a second. Let's go to Fishoff in New Jersey. Both the SEC and the DOJ pursued this one. The defendants entered into a wall crossing agreement. They bought in on investment bankers' secondary offerings in exchange for keeping the confidential information secret. And instead, it was alleged that each tipped the other off on timing and pricing in a short selling scheme. So that case continues to be pending, in which there's a lot of examination of that to see what is going to happen. However, the government has won a few. And in this case, the Conrad case actually was a very significant decision, but this was one in which was not helpful into the government's favor, but it was worth discussing briefly because it also applies to the misappropriation theory. So in this case, Conrad involved an insider trading prosecution of 5 defendants in the Southern District. 4 of the 5 had pled guilty to trading on inside information concerning IBM's $1.2 billion purchase of SPSS. There were 4 traders at Euro Pacific Capital, and one of the traders' roommates, an investment banking analyst, and the government alleged that the banking analyst had received a tip from a friend who was an associate at the law firm of Cravath, Swain & Moore, and who had been working on the IBM deal. After receiving the tip, the banking analyst allegedly passed it to his roommate, one of the Euro Pacific traders, who then tipped 3 other traders, all who allegedly traded on the information. The indictment didn't contain any allegation that the Cravath associate, who provided the information, received any objective or consequential personal benefit representing the potential gain in exchange for the disclosure. So as a result, the government actually withdrew the case and agreed to dismiss the indictment. However, just when he thought things were becoming more clear, Judge Rakoff, who sat by designation in Boston in the First Circuit, decided the Payton decision just a few months ago. And Payton, quite frankly, was almost very well, at least for many observers have looked at it as a very similar case to Newman, however, decided completely the other way. And in Payton, the court, Judge Rakoff, actually upheld the decision where the benefit was pretty close to what had been claimed in Newman, and rejecting the challenge to the indictment and upheld it. So this was the case where the government had alleged there was a split in the circuits, and therefore the courts needed to decide this. At least the Supreme Court needed to decide it. However, the Supreme Court disagreed. So, where are we? Well, we're in a very, very confusing, very unclear state of play. We're left with a situation now where personal benefit is really being decided on a case-by-case basis. It's clear that it has to mean more than friendship and career advice, but it's not clear how much more there needs to be. But what it seems to be emerging from the cases is that there has to be some kind of tangible, identifiable benefit. And there's been some recent statements, especially by the U.S. Attorney here in New York, who recently was commenting just a couple weeks ago publicly when he said that in a case where a CEO, for example, passes information onto a family member or a friend, it is likely, essentially he said, it's likely that they wouldn't pursue a case like that. So you do have a situation where it's a pure friendship situation, or there is nothing more that can be proven, is something now which looks like will not be pursued and will not be upheld by the courts. So if you have that kind of scenario, you're pretty safe. Anything more than that, it's still very gray, and it's still very murky, and still very risky to proceed in the hopes or in the thinking that you won't be charged or that it won't be pursued, because I think that there's no indication that the government, neither the DOJ or the SEC, are going to be any less vigilant on insider trading matters. But unfortunately, the state of play is, and the state of the law is somewhat confused, at least in this area on personal benefit, and here we are. I should say, just cases in the firm where we have several clients now where not remote to be cases, but where the SEC is being very vigilant in pursuing cases where they find anomalies in trading, shortly held positions where there's a significant margin of or gain, and there's been a number of cases where the SEC is pursuing those matters. Appears to have some kind of algorithmic or computer program that they'll be using in issuing subpoenas when they find or perceive those anomalies. So there's no shortage or no holding up of the energy with which the SEC is pursuing insider trading cases. However, in the remote to be context, it's very up in the air, it's very unclear, and I do think at some point the case will go back to the Supreme Court when there's more cases, more law, and more circuits weigh in on it. And if the division and the confusion continues, I would submit at some point they are going to take it, or there's also some proposals for legislative fixes. There's some acts that are pending in Congress to define insider trading, at least statutorily. They haven't seemed to move very much in any direction yet, so that's still also a long way off. So I think for the foreseeable future, we'll be in a situation where these cases are being decided, at least in the remote to be context, on a case-by-case basis, looking at the facts of each case and pursuing them individually. So, thank you. That's all I had on that. So now I turn it over to my colleague, Dave Elliott, who will talk about some equally as important topics, Yates and individual responsibility.
Thank you, Bob. Nice to be with you all this morning. In order to fully understand the climate today of civil and criminal enforcement of the federal securities laws, including insider trading, one must understand the Yates Memorandum. On September 9, 2015, Deputy Attorney General Yates, who was the second in command of the Justice Department, issued a memorandum to all United States attorneys, federal prosecutors, and the Department of Justice entitled Individual Accountability for Corporate Wrongdoing. The opening paragraphs of this memorandum pretty much signal the message to be delivered. Fighting corporate fraud and other misconduct is a top priority of the Department of Justice. Our nation's economy depends on effective enforcement of the civil and criminal laws that protect our financial system and, by extension, all of our citizens. These are principles that the Department of Justice lives with, and as evidenced by the activities of the agents and representatives of the DOJ. One of the most effective ways to combat corporate misconduct is by seeking accountability from the individuals who perpetrated the wrongdoing. Such accountability is important for several reasons. It deters future illegal activity, it intensifies changes in corporate behavior, it ensures that the proper parties are held responsible for their actions, and it promotes the public's confidence in our judicial system. Conventional wisdom seems to be that the white-collar criminal defense and civil enforcement bars would change, and our world would change significantly with the release of the Yates Memorandum. But how much of a change did it really make? Was it really the seismic shift that it has been portrayed? Only time will tell, but it ultimately may not be such a seismic shift. In this portion of our presentation, we're going to describe the memo, and we're going to recall some pre- and post-memo commentary from high-ranking Department of Justice officials. Our view is that the memo was certainly significant because it forcefully consolidated and memorialized DOJ's existing policy on pursuing individuals, but it was not surprising because it hardly announced that policy for the first time. It's slide 75 up there. The memo, as I said, was issued to all federal prosecutors and emphasizes the DOJ's goal of fighting corporate misconduct. It refocuses government law enforcement inquiries on individuals. Next slide. As Assistant Attorney General Leslie Caldwell, who's the chief of the DOJ Criminal Division, said at the second annual Global Investigations Review Conference on September 22nd of this year after release of the memo, the Yates memo codified the DOJ's long-standing approach to entity cooperation in prosecuting individuals. Companies cannot just disclose facts relating to general corporate misconduct and withhold facts about responsible individuals. She noted that overall the new policy guidance builds upon the core considerations of the existing principles of federal prosecution, but also represents a strong step forward to promote and better reflect the importance of individual accountability. She pointed further to statements made before the issuance of the Yates memo by others in the criminal division. Specifically, she remarked that the Yates memo strongly reinforced what Justice has been saying for a long time, and referred to remarks by her colleague in the previous year's global conference by Assistant Attorney General Marshall Miller in 2014, which were discussing the DOJ's approach to investigating and prosecuting corporate misconduct, including the DOJ's commitment to holding individuals responsible. Next, 77, please. There are 6 key provisions to the Yates Memorandum. The first is to be eligible for any cooperation credit, corporations must provide the department all relevant facts about the individuals involved in corporate misconduct. The second is that both criminal and civil corporate investigations should focus on individuals from the inception of the investigation. So there's a reshifting in these first 2 points of Justice focus on both the initial targets of the investigation and the scope of the investigation. It is no longer sufficient to simply focus on the corporation, but both the corporation and the individuals who are involved in the corporate misconduct should be the focus and the target, both on the criminal side and the civil side from the outset. This represents somewhat of a change in terms of guidance from the top of the Justice Department to federal prosecutors in the United States. Heretofore, as my colleague, a former Assistant U.S. Attorney knows, the initial focus was on corporations usually, individuals secondarily. That is absolutely no longer the case. That individuals are to be the focus of the initial inquiry and a continuing inquiry, as we'll discuss in a second, all the way through to the end of the investigation. Do we have a question?
Yeah, would you just comment that suppose the corporation hires an attorney, a law firm, to do that investigation. what does this say about the attorney-client privilege that might be
That's a very good question.
That's a good question. In fact, I was on a panel last week with the head of the Deputy Chief of Fraud, who exclaimed emphatically that there would be no change on the attorney-client privilege, and they would not seek to pierce the privilege. What I think the interesting piece will be is when the corporation hires attorneys, individuals may equally hire lawyers with as equal amount of frequency now, because they're now much more likely to be adverse to their company.
The third point is that criminal and civil attorneys at Justice handling corporate investigations should be in routine communication with one another. Let's talk about that for a second. Internally, we understand that this is a very, very high point, a very much a focus point of the Yates Memorandum internally within the Department of Justice. And that is that the civil side and the criminal side of justice cannot act independently of one another, as heretofore has been the case. And that they have to be in touch with one another from the beginning. There are different burdens of proof that are involved here between the criminal and the civil charges to be made, obviously. But they have to interact with one another in order to decide what's the best way to proceed with respect to both the corporation and individuals. And just because no criminal case might be able to be brought against an individual, that doesn't mean that a civil enforcement case should not be brought. And the two sides of the house have to be talking to each other about that point. Next slide. The fourth point is, absent extraordinary circumstances, no corporate resolution will provide protection from criminal or civil liability for any individuals. Let's talk about that for a second. That's a new emphasis. It was not unusual in the past for a corporate resolution to result in a sweeping release of liability of not only the corporation but individuals within the corporation, and it really wasn't talked about. That is emphatically no longer the case. That guidance from the top of the Justice Department is no corporate resolution will provide protection from liability, civil or criminal, for individuals. And in fact, in her remarks at NYU Law School the day after the release of the Yates memo, the Deputy Attorney General said, if some individual is going to be released as a result of a settlement with a corporation, the assistant in charge, the assistant U.S. attorney in charge of that case, has to get the written permission of an attorney general or the United States attorney for that district to do that. And that's a significant change in terms of the level of responsibility for letting go of individuals. The fifth principle is that corporate cases should not be resolved without a clear plan to resolve related individual cases before the statute expires. Again, a clear focus on individuals and not letting them slip away no matter where they may be. The sixth principle, civil attorneys should consistently focus on individuals as well as the company and evaluate whether to bring suit against an individual based on considerations beyond that person's ability to pay. What does that mean? In the past, the Justice Department on the civil side would principally look at the monetary ability of an individual to pay a fine or a penalty. That's no longer the case. The Justice is very much looking at deterrent considerations here with respect to individuals, and it's not enough to say this individual might not be able to pay and therefore they're going to get released. That's no longer the policy of the Justice Department. Slide 79. As I noted, several pronouncements from Justice before the Yates Memorandum essentially stated policies that were similar to this. Assistant Attorney General Miller at the 2014 Global Investigative Review program said, if you want full cooperation, make your extensive efforts to secure evidence of individual culpability the first thing you talk about when you walk in the door to make your DOJ presentation, and the last thing that you talk about when you walk out. Next slide. There's three previous memos which announced policies which are very similar to Yates. As I said, Yates really seems to be now a more muscular pronouncement and configuration and consolidation of these policies. But going back to 2003, 2006, and 2008, Justice was talking about these kinds of situations. 2003, the then enforcement director, Linda Thompson, a very strong enforcement director, said, too often business organizations, while purporting to cooperate with a department investigation, in fact take steps to impede the exposure, the complete exposure of individuals who might be responsible. And the revisions that she was talking about in her memo back in 2003 made clear that the conduct should be focused both on the corporation and on the individual. We then have the McNulty Memorandum in 2006. Then SEC Enforcement Director McNulty said something similar. The most significant result of this initiative is that corporations increasingly recognize the need for self-policing and looking at inside their own house. Slide 81. Some takeaways from the Yates Memorandum. Since its release, numerous practitioners and scholars have opined that the memo will create unwarranted attention on individual employees, cause confusion for general counsel to represent corporation, to your question, attorney-client privilege issues, conflict issues between the company and the individual, uncertainty for organizations that want to cooperate. How do we effectively cooperate? And the memo largely relates the impact on corporations in their cooperation between the organization accused of wrongdoing and individuals. DOJ has consistently emphasized that the benefits provided to organizations that self-report and cooperate with justice over the course of corporations, and many have suggested that the memo's description of the entity cooperation credit will result actually in withholding information from the DOJ. But Deputy Attorney General Yates made something very clear at the NYU conference, and this is kind of the new sheriff in town pronouncement. She said, effective today, if a company wants any consideration for its cooperation, it must give up the individuals, no matter where they sit within the company, and we're not going to let corporations plead ignorance, and if they don't know who is responsible, they will need to find out. Pretty strong stuff. And she went on to say at the NYU conference, it doesn't matter if they're sitting behind a board seat, it doesn't matter if they are sitting in the C-suite, it doesn't matter where they are, and determine individual responsibility for the wrongdoing at the core of the alleged corporate misconduct. And the other thing that she made clear at the NYU conference is justice isn't going to wait for this to happen. So they're going to proceed very quickly in their focus on both corporate and individual responsibility. So corporations are well advised, it seems to me, given the Yates Memorandum, to make their focus right off the bat in their internal investigation just who's responsible for what went on here. And according to the Yates Memo, to give that up, no matter where that person sits. Our conclusion is that the long-term effects of the Yates Memo have yet to be seen. It's been very successful in raising interest among practitioners, and I'm sure you folks in the audience, and concern about entity versus individual, responsibility, how to cooperate with the government. It's not clear because it's so new, it's just this past September, what signals really are being sent. It is clear to us that it is suggesting, as I said, a more muscular approach and a finer focus on individual responsibility and incentives for corporations to do the type of investigation that the Justice Department wants them to do. As to whether the memo will consistently have those desired results, only time will tell. Thank you.
Our second and final panel today consists of Dave Pitney, partners Hank Massey and Rick Harris, counsel Eliza Fromberg, and Dennis McCarron is the CEO and founder of Regulatory Maven. Hank and Eliza specialize in broker-dealer/RIA legal and regulatory matters, while Rick chairs the firm's technology, telecommunications, and outsourcing practice group specializing in cybersecurity. Regulatory Maven offers compliance services among a broader range of financial services to security industry firms and professionals. Hank Massey will be moderating the panel. So, gentlemen, please welcome our panel.
Okay, thanks everybody. Everybody hear me all right? It's a little bit of
Yeah, we've got a little feedback here.
feedback. Maybe
See if we
I'll
turn
move
off
this.
some of the other microphones.
All right, can everybody still hear me? I'll speak up. So thank you for coming, and I'm glad to see everybody still here after the break. So first off is going to be Dennis McCarron speaking about proposed amendments to Form ADV. And as you know, the SEC had a large backlog in rulemaking after Dodd-Frank was adopted in 2010. They pretty much caught up on the rulemaking. And one initiative that they're now that they've started, and hopefully they will take action on it at some point, which Dennis can talk about, on the basic RIA form, which most of you know is the ADV form. So, Dennis?
Thanks, Hank. Good morning, everybody. How are you? Thanks for coming in. One point that Hank just said was the SEC has adopted a lot of the Dodd-Frank rules, but that hasn't totally triggered or slipped down to the FINRA side. They're still going through their NYSE and NASD combined manual. So one of the things that you want to look out for when FINRA comes into your offices is make sure that your rules are up to date, because that's a gotcha. Okay. You know, when Mary Jo White took over, she came out and she was making it very, very clear that she wanted to create true transparency within the industry, not just for investors and not just for investment firms and broker-dealers, but also for the examiners, to help the examiners get better information quicker and be able to come in and do a more efficient exam. So one of the things that I'm sure you've heard her say is she's labeled bad actors. And that is her vigilance. She really wants to get and identify and scold those bad actors at any level. She's put a lot of tools in place, which we'll get to at the end of this and try to pull it all together for you. But this proposal is about a 102-page proposal, so obviously I'm going to skim across a lot of it in a matter of time, and we can talk at any time about any particulars that you may have. So, slide 2. The big pieces that they're looking at on the proposal is separate managed accounts, and everybody knows what a separate managed account is. It's a fund-to-one. Umbrella registrations and books and records. So, slide 3. The proposal on separate managed accounts in ADV, there's not a lot of depth on what you report for your separately managed accounts. Right now, regulators are looking at and going into your firm, and they're looking at your books and records, you're looking at your financials, your portfolios, your trading, and so on like that. Right now, they want to pull a lot of this information out. So the ADV is going to take more hours to put together, which we'll get to, and it's going to require a lot more information than you currently have. A lot of it is check the box. So they're going to look for the percentage and types of clients that are in your SMAs, the AUM that is associated with it, and then they're going to look for about 10 different broad categories of different types of securities, ETFs, U.S. government equities, microcap derivatives, alternatives, and so on like that. And they're going to require reporting. So on your ADV and your annual amendment, you have to have that done within 90 days of your year end. And if your assets in SMAs is greater than $10 billion, you're going to report 2 figures on that annual amendment, a mid-year figure and a year-end figure. If your assets in there is 150 million to 10 billion, to less than 10 billion, you'll report just a year-end number. Now, what this kind of ties into a little bit, if you're familiar with Form PF, that's a new form that came out in 2013. and they look for more information on that. So they're adopting a little bit of this, and they're starting to encroach in the ADV on different reporting of assets and asset types now that they haven't done in the past. Also, if you have multiple custodians on the RIA, and you concentrate more assets of, say, 10% or more in any one specific custodian, you're going to have to disclose the custodian as well. So they want to be able to know who the custodian is, and they want to be able to go to those advisors if a custodian is having a problem. Whether it's a financial or operational problem, they want to be able to pull up very quickly that, you know, XYZ RIA and ABC RIA are using this custodian. We're going to go to them and give them a heads up so that they can look into any measures that they have to do to protect their clients as well. So it's all about trickling down, as you'll see. Next slide. The number of changes, there's a number of changes that are going to go on, and I'm just going to briefly hit upon a couple of them. You know, one is the internet, your website. Social media, as we all know, has been a really big piece of controversy with the SEC and FINRA on have they brought real clarity on how and what they expect you to do to supervise that, especially for your wealth management firms that use Facebook, that use Twitter, that use you know, LinkedIn and so on like that. So you're going to have to now label out what you use, and you better make sure that your procedures are in place and they correlate highly with what you're putting out in the public on your ADV. This may also trickle over into your ADV 2A, your brochure as well. Branch office structure. For those who have a broker-dealer, you're probably familiar with BORAM, which is the Branch Office Risk Assessment Matrix. The SEC has never really looked at your branch structure. They go in and they say, okay, your main office is here. They come in and they take a look at it. Let's assume that your branch office structure is really to service individual RIA offices throughout the country. They'll come into your office and they'll say, okay, let me do an examination. Where are your assets? Where are your advisors? Well, we really have no advisory business here. This is just a processing center. Now today, they don't have to go to you because you're going to be disclosing who and where your assets are being held, and not held, but managed. So they can go directly to those branch offices. So let's say you're a $1 billion firm and you got one branch with $250 million and another one with $500 million. They're going to go directly to that $500 million and $250 million branch, and they're going to go in and they're going to do a regular exam like they would be doing in your main office. Do you really want them to do that without your knowledge? And do you want to make sure that branch manager is well trained in your compliance program? Because if they go in and say, so tell me about your compliance program, where's your compliance manual? And the guy looks at him, or the woman looks at him, you know, with deer in the headlights, that's not a good first impression. So you want to make sure that you know and you've trained your people very, very well on what's going on, because you don't want that happening in your business. Outsource CCOs. You know, a lot of firms that are not complex, that that have a low asset level, you know, because they can't afford a full-time CCO. And I'll say it's like $50 to $75 million in assets. Anything above that, you probably could hire a CCO, because if you're the president, chief operating officer, and CCO, that doesn't bode well with the regulators either. So you can outsource that, and when you outsource it, today you don't disclose anything other than the CCO. Now, with this proposal, you're going to be disclosing who that CCO is, where they're from, what their tax ID number is, or what their social security number is, what their CRD number is, and so on.
So is that going to cause the SEC then to identify CCOs who are the outsourced CCO for like 100 companies or 100 investment advisors? Yeah,
they'll, you know, each one of these, each field in your ADV is a searchable field at SEC, so they'll be able to do a query and just pull that information right out. So let's assume that the SEC goes in and they examine 10 firms and it's all the same CCO and they all have the same problems. Well, they'll now go and they'll do a query and find out who this individual is CCO for other firms. I mean, I've seen CCOs handle 10 and 20 firms. I don't think you can do an effective job except cash your check at the end of the day. You know, if you decide that you want to outsource your CCO, interview them. Find out how many companies they do CCO business for, what their track record is, and do some due diligence on them. If they're doing more than 4 or 5 companies, I'd probably take a second look. But this is now going to be disclosed. Client categories. This is a big one. If you take a look at your ADV right now and you check the box, I do business with high net worth, ultra high net worth, and 25% of this category, 25% of this category, 50%, the line goes down. You're going to have to now associate client accounts, not account numbers, but the number of accounts, the assets, and probably a couple of other different things that they're going to want to know so they can drill down. And remember what I said, each one of these fields is searchable. So they can query this and pull this information out. So they can do global, regional profiling on different firms to figure out what they want to do and where they want to go. Wrap sponsors. They're now going to look for more information. What's your distribution about? If you're the managing manager managing the wrap, they're going to want to know who are you distributing it to. So if you have a problem, they're going to be able to go to all your distribution and say, hey, XYZ has a problem, they've been doing some wrong accounting, they're outside their style drift, whatever it might be. And they automatically now know who to go to because you've disclosed it on your ADV, and on the other side, they've disclosed it on their ADV that you're one of the managers. So there's a lot of information that they're going to be able to pull out of here. The next one is 120-day. This has been, I guess, some confusion in the industry, and that's why they're changing it up. They're now going to call it investment advisor expecting to be eligible for commission registration in 120 days. They want legal status. They want to know, are you an LLC, and so on like that. The relationship that you have with certain securities. Now, they haven't really defined what certain securities is, but they want to know what the relationship is. Do you own it? Are any of your advisors on the board of directors? Any principals on the board of directors? Do you trade it often? Is it part of multiple portfolios? They want to know what you're doing with certain securities, and that'll be flushed out, as they come closer to implementing the change. For the hedge funds, and if you have custody, supervised audits or surprise audits, they want to know the PCAOB number and so on, but they added another little piece of information. They want to know if there was a qualified opinion provided on it, and that is going to help them understand who the PCAOB firm is, what the opinion was, and now they also have a track to go right to the PCAOB firm and say, what do you mean by this opinion? So it's another piece of information that is going to help them, those numbers you put up, disciplinary. If they have found if the courts or the regulators have found in favor of you or your firm, you're going to be able to remove that. And they're expanding it to include criminal, regulatory, and civil actions. Performance data. Usually this goes under your advertising and your communication retention. Normally it's 10 people, and you got to be able to pull it together and add and hold it up, retain it. Now it's for anybody, and they're also looking to go deeper. When you send out performance data to one client or 1,000 clients, you've also got to provide them with the data and the calculation used to get to those numbers, and that has to be retained. This is just some stats on the industry. And, you know, if you look, and these stats here were actually in the SEC proposal. So does this, if you look at it real quickly, does it kind of give you a roadmap of where they're looking and what they're doing? You know, this helps you understand where their focus is. And, you know, these SECs, they're not stupid. They know what they're telling you. The next slide is the cost analysis. This can be a costly effort, as you can see. I believe the smaller firms are going to have more difficulty in managing the initial upload or the initial gathering of data for the ADV, because it's information that you may or may not have readily available, especially on the wealth management side. You're going to have to really rely on your custodian to be able to help you provide sliced and diced information so that you can fill the boxes on all the information that they're going to require to do this. And that's going to be costly. It's also going to be time consuming. And I'm sure there's going to be businesses out there and maybe even your custodians that might help you gather this information, you know, for a fee, which adds to your cost. Next. So, transparency. You know, Mary Jo White, she said, this is happening and I'm making it happen. So if you take a look at what she's done about over the past few years, she's put a lot of tools into place. One, she's trying to increase her examiner base, and she didn't get exactly what she wanted, so she reformatted her budget to build tools in place of that. And there's a couple of tools that she's put into place that have worked and they're proven right now. One is called the National Exam Analytical Tool, or NEAT. I'm not sure if you're familiar with that. This is a technology that's used to access trading data from firms. So they're gathering this information from your custodians, your clearing firms, your prime brokers, wherever it is you're actually executing your trades. And they're comparing that trading data at the firm level and also at the IA level. So if you have IAs out there that are actually running money in their trading client portfolios, they're getting that information because it brings up your firm code and it also brings up the trader's firm code. And then they're comparing that to a corporate activity base. So if you think about, Bob talked about the IBM thing, and this is probably a bad scenario, but you've got IBM out there and they're about to make a purchase. And that information, all of a sudden, one of your firms traded, you know, 100,000 shares of IBM. And within 2 or 3 seconds after that, the announcement was made. I think you're bagged. Now, normally, a few years ago, before NEAT was put into place, you may have gotten away with it unless somebody leaked. Now, you've got this information that the SEC has and it red flags it. And that's why we call it the red flag seminar. But they red flag it. And now I've identified a corporate action or a corporate activity, and they've also identified a trade. Now the trade is for inside information. Then you can go front running, you can go asset allocation. There's a whole lot of different information that you can get from that, and that's at the firm and IA level. The second piece is market information data analysis system, MIDAS, and it's not the muffler shop. This here grabs data across all exchanges. So you've got the micro data collection and you've got the macro data collection. Now what this does, this can take a look at trading trends. It can take a look at specific market crashes or corrections, and it analyzes that information. And this information is actually on the SEC website, but you got to really know what you're looking at to understand what it says. And a trader probably would have far better insight into this than I would ever. But that information is there. So you look at MIDAS and NEAT, two proven technologies that the SEC has used. Now all of a sudden Mary Jo White gets the idea of, let's update the ADV. This was her plan. Now, she takes that information, she drills it and compares it over to the ADV, and she knows exactly what your firms are doing, who they're doing it to, why they're doing it, and who in your firm is doing it, before they even walk in your door. So, talk about a proactive program from a compliance and regulatory perspective. It's scary. Now, hopefully, they're training their examiners well enough so that they know what they're looking at too, and they don't have the. Anybody from FINRA here? They don't have the FINRA gotcha. You know, they're trying to be a little bit more conscientious and respectful, but they're also executing what their job and their role is. You know, if FINRA had this information, it would be a gotcha. The SEC, they're just going to get you if you're doing it wrong. That's really about.
Any questions?
Just a curiosity question, would Midas have caught the fraud, what's his name? Just popped out my head. The guy who had the pyramid scheme?
Oh, Madoff?
Madoff?
Just repeat the question.
What the question was, would Midas have caught the pyramid scheme from Madoff? Probably not, because I don't know what his trading habits were. You know, he was more into the just defrauding.
Okay.
Great. Thank you.
Thank you. Let's move on to our next panelist, Eliza Fromberg. And some of you may be familiar with the appetite that investors had to buy Facebook shares before Facebook went public, and there were a lot of activity, a lot of legal restrictions. That same thing is happening now with the pre-IPO companies, and Eliza will talk a little bit about the buying and selling of shares for a company that is not yet public.
Thanks, Hank. Is this on? No. Other way? Oh, okay.
Bring it closer to you.
Better? Okay.
There you go.
Yeah. Okay, so as you may remember, during the dot-com bubble of the 1990s, companies were racing to go public. This is when I had just graduated from college, and it seemed like everyone was starting a company and going public, except for me. But now, as we've seen, companies are staying private much longer. It went off? Maybe I should take yours. Maybe this is just not working.
It's like the battery.
Better. On?
Yes.
Thanks. Okay, so as we've seen, companies are staying private, much longer, and there are a bunch of reasons for that, which I think people understand. First of all, it's the costs associated with being a public company. Also, the Jobs Act has made it much easier for companies to stay private longer by raising the threshold of shareholders of record from 500 to 2,000 before you're subject to mandatory SEC registration. And it's also easier to raise money through private placements. A lot of the private placement rules have been relaxed in recent years, making it easier for companies to raise money that way. So what we've seen is a lot of private companies that have really crazy valuations. You think of Uber or Airbnb or Snapchat. And who owns these companies? Mostly it's early investors, it's VCs, and it's current and former employees. Now, for a lot of these current and former employees, as companies are waiting to go public, they have a lot of their net worth tied up in private company shares. And a lot of these current and former employees want to sell. They need liquidity. So how do they do that? At the same time, on the other side, there are plenty of investors who really want access to these private company shares. They want to get in on the ground level. How do they get access to these private shares?
All right, and Eliza, even with the restrictions and the difficulty of trading these private shares, is it a big market?
Yeah, I mean, it's not just hype. I mean, according to the Wall Street Journal, and no one really knows the actual amount of the secondary market, but the Wall Street Journal estimated that from $10 to $30 billion in stock changed hands in pre-IPO trading in 2014. So it is a significant market. So what should what are things to keep in mind? First of all, these days, unlike back when you heard about Facebook shares trading on second market, now most companies actually have contractual restrictions on their employees when they're granted private company shares. So the employees generally need to get their company's permission before they can trade their shares. So sometimes this takes the form of the buyer signing an NDA with the company and getting certain financial information from the private company before engaging in a transaction with the employee or former employee. More likely, what we've been seeing lately is companies have a right of first refusal. So in that kind of program, the company has a bunch of deep-pocketed investors who they keep up to date on what's going on with the company. And when employees come to the company wanting to sell their shares, the company refers them to these right of first refusal buyers, and the company helps facilitate the transaction by providing the forms for the share transfer. Also, some particularly large private companies actually have liquidity programs. Like they'll do a tender offer for their own shares, or they'll have a company-selected institutional investor who will come in and make an offer to employees at a set price for a set number of shares. So that's one option. Again, we had seen in the past, like Second Market, which is a private marketplace where people traded shares, are actually becoming less prevalent. In fact, it was just last week that Second Market was acquired by NASDAQ Private Market. And Second Market, which used to facilitate one-off trading in private shares, several years ago went to just facilitating company-sponsored offerings. So you can't even trade your individual private shares on Second Market or NASDAQ Private Market anymore. So those are challenges. Another challenge is this went out again.
Another one. Go on.
Okay, another challenge is what's the right price? I mean, you want to buy a private company share. How do you know?
Well, and Eliza, so if the company's cooperating, at least all the parties. Right. If the company's not cooperating, how do you get over the problem where the seller, the employee, has access to the company financial information, but the buyer is not allowed to get that information?
Yeah, you have a real disparity of information, and it's interesting. I mean, we haven't seen, and certainly Bob and Dave can talk about this. We haven't seen insider trading type cases brought in the private company context. I mean, all these cases are in the public company context, but I worry whether you could see a kind of insider trading case brought involving private companies. I don't know, but maybe we will see that at some point. And then transaction costs. I mean, certainly any intermediary facilitating a private company share transaction is going to charge a very high fee, both because these kind of shares are in high demand, and also because there is a lot of paperwork involved in facilitating this kind of transaction. So not all that easy. And then we haven't even mentioned the securities laws, which obviously you have to comply with. First of all, the seller wants to avoid liability for making an unregistered public distribution. The way people typically do this is they comply with the Rule 144 safe harbor. So a person that complies with all the conditions of Rule 144 is deemed not to be engaged in a distribution of securities, and thus is not considered to be an underwriter. But it's not always easy, especially in this context, to comply with Rule 144. And why is that? Well, if you think about the most common scenario, is you have a private company employee who has options. And what they typically want to do is to do a cashless exercise of their options. They can't do that or it's very difficult to do that with Rule 144 because of the holding period. So say you have options, you want to exercise them, you don't have the cash to exercise them, but you have to hold them. You have to hold your shares for 1 year, pursuant to 144 typically, before you can sell them. So you have this gap that you don't have the cash to exercise the options, and you can't do a cashless exercise because of the holding period. So that makes it really difficult for a lot of holders of private company shares to use Rule 144. Plus, if you're an affiliate, if you're an officer, director, or 10% shareholder, it's much more difficult to sell unregistered shares because there has to be current publicly available information about the issuer, even if the issuer is non-reporting. And many private companies simply are not going to disclose the information that an affiliate would need to be able to sell their private company shares. So 144, not really a good option for a lot of sellers. Another option people have looked at is using reselling these privately placed securities in a subsequent private placement using what's called the Section 4A 1.5 exemption, which as it sounds is a hybrid exemption, and it's actually case law derived. There have been proposals to actually codify this, but at the time it's kind of an exception that lawyers have come up with, where you're melding the rules that apply to sales by people other than issuers with the same safeguards that apply to sales of private shares by issuers. The problem here is that it's very expensive. In order to facilitate a Section 4A 1.5 transaction, you need an opinion of counsel, which the selling shareholder needs to obtain, which says that the shares were sold pursuant to a valid exemption. And often that is, more than the selling shareholder wants to deal with in order to sell their shares. Plus, you have to know the blue sky laws of the state in which the buyer has their residence. Again, blue sky laws add additional costs to facilitating that kind of transaction. So, the market has gotten very creative because, as you can tell, now that there are a lot of contractual restrictions on selling these shares imposed by the company, people really do, especially former employees, do really want to unload their shares, especially if the liquidity event seems to be nowhere in sight. So what are some interesting things that we've seen? We've seen middlemen who are trying to arrange transactions that allow employees to get money for their shares without actually selling them. So basically kind of transferring the economics of owning a private company share without the voting rights and other rights associated with owning that share. So from the issuer's perspective, their cap table remains the same because they don't actually see a transfer. So what are some ways that we've seen people trying to do this? One of them is having employees pledge their shares to the purchaser as collateral for a loan. So the purchaser is paying the loan proceeds, which are essentially the purchase price of the share, to the shareholder in exchange for this collateral. And upon a liquidity event, upon an IPO, the loan is forgiven and the transfer takes place. So again, you can imagine there are some challenges in documenting that kind of transaction. But again, there has been no transfer, and some of these are done with the company's permission, and I believe some of them are probably done without the issuer's permission, because again, from the employee's perspective, there has been no transfer. They're not in violation of their contractual restrictions on selling their shares.
You have to be very careful about exactly what the contractual restrictions are, because sometimes there's a restriction against a pledge of the shares. So
Right.
it depends how tightly the company has written the restrictions.
Right. Another even more creative solution, which was actually the subject of a fairly recent enforcement action against Sandhill Exchange, is that this intermediary actually designed a derivative that delivered payments to company employees based on the stock's perceived value. Again, I don't know exactly how they structured that, but in fact, the SEC brought an enforcement action finding that this type of derivative transaction violated Dodd-Frank because Dodd-Frank makes it unlawful for most individual investors who are not eligible contract participants in derivative language to transact in swaps, except if it's on a national exchange. So that particularly creative way of facilitating a transfer of a private company share was found to be in violation of Dodd-Frank. But it does seem like there has been more attempt to make a creative solution that would not be a swap as defined in Dodd-Frank, and for example, setting up private funds that do invest in loans, as we talked about earlier, for private company shares. And we've also seen enforcement actions where investment advisors set up private funds which were designed to purchase private company shares and raise money, and then did not actually purchase the private company shares. So there's certainly a lack of transparency in this area, and it's very challenging. And I don't see an easy way for former employees, to get liquidity for their private company shares because of the contractual restrictions and because of the increased regulatory scrutiny in this area. So it will be very challenging.
So I'll ask if anyone has any questions, but I'll also ask whether any of you have had clients come to you or have dealt with this secondary trading of private company shares. Yes. Oh, you have. Yeah.
We turned it down. Yeah.
Right.
But Facebook.
Right. So some, just so people can hear, some audience members have said that they have been approached with that proposition, but have turned it down because I think the regulatory issues are very challenging. Any questions? Okay. Thank you, Eliza. Let's turn to Rick Harris. And cybersecurity, as I think you all know, is a continuing hot topic for broker-dealers and investment advisors. And Rick gave a very comprehensive presentation last year, and we're going to ask him to update for recent developments.
All right. Since Eliza killed several microphones during her, that was amazing. I've never seen that done before, but you killed 2 microphones in the process. Hopefully you can all hear me.
It's my dental work.
No, it's actually that there was some cyber attack going on while we were standing here. You may remember Kevin's slide. Let's see whether you were all awake at the beginning of the program. You remember Kevin's slide about sleep deprivation. What's keeping your CCOs up at night? I'm going to tell you this is what's keeping your CCOs up at night. This is actually live data. These attacks are occurring as I'm speaking, and you can see they're coming from all parts of the world. A lot of attacks are coming from Asia. We've got plenty of attacks coming from Eastern Europe, and then the big bombings that you're seeing there, those are the areas that are being attacked. The United States happens to be a very popular area for attacks. So I thought I'd show you that. Last year when I was here, and they always seem to bring me here right around Halloween. I guess it's because I'm the spooky guy, right? I get to tell you all the things that will keep you up at night. I'm sorry, Kevin, I know we're supposed to be helping them. So I'm going to tell you some of the things that should be keeping you up at night, but I'll also talk about some of the things that you can do to actually breathe a little bit easier. Last year, when I came here, and I'm going to just switch this back to stop scaring you all there. When I came here last year, we talked about a lot of the traditional stuff. We went through the history of cybersecurity regulation and compliance matters, right? We talked, some of you who are here, I know I recognize a few faces. We talked about Reg SP. We talked about the red flag rules, right? We talked about the implications of Dodd-Frank, Reg SID. We also talked about the state data breach laws and some private litigation. But all of that, a lot of that was really focused on what happens after the attack. How do you respond? And you know, what do you have to do in order to give notice to consumers and all of that. This presentation is going to be a little different. We're going to look at what's happened this year. Hank, you really thought I needed a microphone, huh? So we're going to talk about what happened this past year and what might have changed, because what we saw in the prior years was a lot of backward-looking stuff. The regulators were very interested in saying, well, what did you do after the attack happened? Now we're beginning to see the regulators look at something different, which is what are you doing? What did you do in advance to prepare to respond to an attack? We see a couple of things up on this slide. In January of 2015, the Office of Compliance Inspection and Examination issued its national exam alert. This was really a summary of an examination sweep that they had conducted earlier in the prior year. So it was right around the end of 2014. They examined 57 registered broker-dealers, 49 registered investment advisors, focusing on compliance issues associated with cybersecurity. You should read this report, and I tried to provide the URLs for each one of these, but you really should go out and read that report. It is shocking as to how many of these broker-dealers and RIAs were not prepared for that compliance audit. In March, the CFTC comes out with an address and says, look, probably the single most important new risk to market integrity and financial stability is cybersecurity, right? Cybersecurity. And the CFTC already has a regulation, those of you who know about it, right? It requires market actors to provide administrative, technical, and physical safeguards to prevent the stealing of customer information. You shouldn't only be worried about customer information, right? You have to worry about your own proprietary information, right? What about those proprietary trading algorithms that some of our clients have and are trying to protect? In August of 2015, the NFA announces that it believed, and this was in a letter, which again I really encourage you to go out and pull up that letter. It's worth reading. But they announced that they believe that members should have supervisory practices in place. And this is important though, right? They said they need to be reasonably designed to diligently supervise the risks of unauthorized access. Well, what were they really saying? It says, not every broker-dealer, not every RIA needs the same level of protections. A small broker-dealer with 1 to 5, 10 broker-dealers might have less risk associated with that organization than one with 1,000 broker-dealers and 50 offices across the country. So reasonably tailoring your program is appropriate, and in fact the regulators have agreed with that. In September 2015, the OCIE chairman Massad announced that the CFTC was working on a rule proposal related to cybersecurity. So you'll have to come back next year, right, so that we can talk about what those rules are. Originally, we were thinking those would come out near the end of this year. I am willing to put a bet that it won't be by the end of this year. It'll probably be early next year. So you're definitely going to have to come back. Let me tell you just a story to put this all in perspective. How many of you use laptop computers? How many of you from time to time might have customer data or other proprietary information on those laptop computers? I already saw one raised hand, but go ahead, raise your hand. I know some of our partners here sometimes do have that, right? There's nothing wrong with that, right? Nothing wrong with that. But how many of you use encryption software so that everything on that hard drive is encrypted? So I see 1, 2, 3. I see just a few hands, right? And then I see a lot of blank stares saying, encryption software, what are you talking about? So in May of 29, 2014, a company, a broker-dealer, had a technology employee who left his unencrypted laptop in a restroom. That unencrypted laptop contained account numbers, client names, client addresses, taxpayer IDs, probably dates of birth. And by the way, the data was all of the account data, all of the clients from 1992 to June of 2013. So there are so many things wrong with that, right? I mean, first of all, why were they keeping data from 1992 to 2013? Why was it on a laptop? Why was it unencrypted, right? There are going to be a lot of questions. Well, this entity, Stern AG and Leach, I don't know whether you all heard about this, but they entered into a consent order in May of 2015, paying fines of $225,000, along with a lot of other things. By the way, that $225,000 was a drop in the bucket compared to the legal fees, accounting fees, and remediation costs that they incurred that they could have avoided had they avoided certain things. But what's the story here, right? Well, in 2009, a bunch of years before this incident occurred, the firm had done an analysis. They properly recognized the need for encryption of laptops, and they identified it as a moderate risk, so it wasn't urgent. Well, this was 2009. In 2009, it would have been appropriate to identify this as a moderate risk. But as time goes on, right, risks change. So if you're not periodically reviewing your analysis, you better do that. Well, so they identified it as a moderate risk, but in 2010, they actually purchased software that could go on the fleet of laptops. But when the IS team asked for funds to go and implement this on all of the laptops, management denied the funds. Well, it was only a moderate risk. You know, it's not time to spend that money. So in 2013, IS actually says, oh, well, we're going to buy a new software. We never used the old stuff, so we'll buy new stuff. Again, went out, identified new software, again, asked management for funds to go and implement this new solution. Management, again, denied the funding. So when FINRA comes in, right, they found that the firm's written supervisory procedures didn't require encryption of laptop hard drives because it had only been identified as a moderate risk in 2009. That's like, you know, in the Stone Age, right? They found that the broker-dealer had violated Reg SP, NASD Rule 3010, and FINRA Rule 2010, right? Fines imposed, costs. Does this scare you? You know, is this?
And also, what I think is really interesting is that they never found the laptop, so probably somebody took it and wiped it and sold it. Probably, right? Probably nobody got the data.
Yeah. But the cost to the company, right? Even in terms of the public relations hit, when they had to go back to clients all the way to 1992 and say, we lost your data. You know, some of those clients were scratching their head saying, who are you, right? Why are we retaining data? Well, you know, that leads to, you know, an important concept, which is you need to think about the data that you're collecting and storing. Should you flush data? Now, the marketing minds in this room are all saying, no, I got to keep all that data because those are future clients, once and future clients, right? Bad thinking in this age of, remember those cyber attacks that are happening right now. Next slide.
Rick, was there a class action for the images by the affected customer?
In that case, Dave, there wasn't, and we will talk about the class action issue near the end if we have time. I know we're sort of limited in time here. So let me talk about one regulator's areas of focus for their exams. And again, they've announced this, right? They've even given us the questions they're going to ask during the exams, right? So if you haven't gone and looked at these, right, and planned what your responses are, you know, I'm encouraging you, you'll sleep better if you do that now, right? Go home right now, go read these. We even have a program now that we're working with some of our clients where we'll come in and do what we call a mock examination and ask all of the questions, and then you sort of get a rating. So what are some of the areas of focus? And I picked on OCIE because it happened to be the latest one that came out. If I went to any of the other regulators, they've all announced something very similar. It's all along these lines, right? And it starts with governance and risk assessment. Not only are they going to ask you, do you have documentation? Because I'll bet all of you have policies and procedures that we could look at, right? The question is, when was the last time those policies and procedures were thoroughly reviewed and evaluated against current risks? And are your controls and risk assessment processes really tailored to your organization, right? And I know, our panelists here come in and ask that question all the time, and it's amazing. You're going to hand me this thick manual that you got off the internet, right? Getting it off the internet and saying that's my plan actually doesn't put you in compliance. How about access rights and controls? What's that all about? How many of you can access your firm's system and customer information from your home computer? Okay, quite a few of you, and that will be growing, right? As we have more and more workers working from home, we believe in remote workers. This is we've got the millennials who actually like to still work in their slippers. That's okay, right? That's okay. But do we have the infrastructure in place to protect, right? One of the issues that the regulators and the examiners are going to look at is, hey, how do you control remote access? Do you use multi-factor authentication? Anybody know what I mean when I say multi-factor authentication? How many of you have these these key fobs? There's these little things, and you push a button and a random number comes up, right? Or you might even have it on your, I also have it on my phone as well, right? So I've got these, I use it to access my bank accounts. I use it to access our firm systems. Multi-factor authentication, it means not just username and password, but one more thing that you actually are in possession of that nobody else could have unless they've gotten you to give you your username and password, and then they get hold of this physical thing. So that's multi-factor authentication. But that's the kinds of things that are going to be looked at. How about data loss prevention? Right? Examiners may assess the firm's volume of, whether the firm monitors the volume of content transferred outside of the firm. I mean, I know we do watch that, right? So if we see unusual activity where there are emails with really big attachments going on, it's something that actually gets flagged here and investigated. When it's my account, they don't worry because I'm always doing weird things. I'm a tech guy. At least that's what I claim, But it is something that if you don't have that in place, examiner's going to look at that, and you're going to get dinged on it. How about, and there are probably two on this list that I want to really highlight, and that is vendor management and employee and vendor training, right? So vendor management, what are we talking about here, right? Vendor management has really three aspects to it. Due diligence going in, right? If you're going to give a vendor customer information, have you done your due diligence to understand what security measures they have in place to start with? Then there's the contractual piece, right? So due diligence, the contract terms. Do you have appropriate contract terms that allow you to come in and do inspections, get you appropriate audit reports, have appropriate reps and warranties, and then finally, you have the ongoing monitoring, right? So I did good due diligence at the beginning. I had some good lawyer at Day Pitney draft up all these great provisions. Did I ever do anything with my rights to monitor, right? Did I even look at the reports that I was getting that said that they were deficient in their security, and I never looked at the report? All of those things are what will get you in trouble, and in fact, state law is sort of converging on this too and saying you have an obligation under state law to protect customer information by looking at your vendors. And these class action lawsuits are very targeted. So the civil actions that we're starting to see, the private causes of action, are starting to trigger off of these kinds of things. And then finally, I want to focus on training, right? Training from the bottom up and the top down. You know, in order to get your employees to feel invested in data security, right, they have to understand data security. And you know, if I had more time, I'd tell you the story about having, you know, a parking card that I wanted to get, so they handed me a form, and that form had my name, my employee number, and my social security number. That's what they wanted me to put on the form. And I fill it out, I hand it to my secretary, she duplicates it. I now have 2 copies of this thing. One sits on her desk, the other goes down to Parsippany, New Jersey. God knows where that is, right? So it goes to Parsippany, New Jersey. Somebody opens it, makes another copy, makes an electronic copy, right? They're replicating this information all over the place. My secretary should have stopped that if she understood data security. She's a great secretary, but what did she do? She just followed the rules rather than saying, gosh, doesn't it seem weird that they needed my social security number in order to get me a parking card? Does that seem weird? Okay, seems weird to me. So, you know, I want to just get you to start thinking about that. Let's go to the last slide. So let's just wrap up. And I was kind of jealous that Kevin got to do a crystal ball act and predict the future, so I'm going to predict the future too. Last year when I predicted the future, I'm going to tell you that I was 100% right when I predicted the future at this program. You can go back, find the videotape, good luck to you. But I know I was 100% right.
I think we erased that video.
Yeah, we erased the videotape. But unfortunately, right, unfortunately, or you learned that I was 100% right. But you come back next year, and if I wasn't 100% right, I'm going to buy you a cup of coffee at this program next year. So here are some of my predictions. The number of actors involved in cyber attacks, cyber terrorism, cyber espionage is going to increase in the coming year. Do you think that's a fairly safe bet, given the trends that we've seen, right? Given what I just showed you on the screen at the beginning of this presentation? This means both state actors, private actors. The criminal circuits, I got to tell you, the criminal rings involved in this are incredible, and Bob's like shaking his head going, yeah, I know, I sat on the other side of this and watched, right? There are marketplaces for personal information. You know, there's actually market prices. I can tell you, you know, what it costs you to get a social security number. You want one with other information like, you know, mother's maiden name and all that stuff. You know, that package runs a little higher. There are even marketplaces where if you want that delivered to you quickly, they have expedited service and they'll charge you an extra $350. They'll expedite the delivery to you. I can predict that the number of regulatory examinations is going to increase, and the regulators are becoming much more structured in their approach. Now, you know, that's an easy bet, right? Only because I've got 5 regulators telling me that they're going to increase examinations in 2016. But in terms of the increasingly more structured, right? They're being very transparent to us, right? They're giving us the structure. So we should take advantage of knowing what the structure is to improve and harden our own cyber security. Regulators are going to expect adoption of standard-based securities frameworks. You see a bunch of terminology up there. If you don't know what that terminology is, you should certainly go to your compliance officer and ask your compliance officer if they don't know what that is, or whether they know what that is. If they don't, you should find a new compliance officer. You know, I don't mean to scare you, but right, they got to know this stuff these days. The standards of care are going to require greater emphasis on vendor due diligence, monitoring, and enforcement. We talked about that. How about the standards of care for directors and officer engagement is going to be increasingly vigorous. I will tell you that the SEC, FINRA, everybody's very focused on the question of whether directors and officers were engaged. So we talk about have you trained your directors and officers? Have you trained the people at the bottom of the pyramid and everybody in between? And then finally, I want to focus you on an increasing reliance on cyber risk insurance coverage. I was very skeptical of these policies when they first came out. I think the way they're being packaged now, along with remediation services, response services, etc., make them much more interesting. And there's lots of cross-pollination and information flowing from the insurers now. I will be available for questions afterwards. I needed to finish by, well, 2 minutes ago.
Excellent job. So we have another 15 minutes allocated for questions, or I can ask for any other comments.
Okay.
Yes, sir.
Yeah, I just have this on the cybersecurity. One of the areas that seems to be high on the risk is the employee side of it, answering an email that has an attachment that's got some sort of virus in it. Is there any easy way to attack that other than employee training?
Yeah. So
Did everybody hear the question, by the way?
yeah, and I'll repeat the question for those of you who didn't hear. I don't know which microphone is working anymore. Okay.
These two are.
So let me repeat the question. The question was whether there is any easy way to avoid employees clicking on these emails that carry viruses. The sad answer is no. And the reason that it's so difficult, and you may want to respond to this too, but the reason it's so difficult to protect against this is these viruses, the vectors of attack, are constantly changing. Now, you should be using, right, probably a third-party product that scans for viruses in advance and scans for known scammer emails and the like. So at our firm, a lot of that stuff gets blocked before it comes. But I can tell you that those services aren't going to block every attack, and they'll never promise to, because the criminal rings that are out there are really, really good. So it really does come down to employee training. If you see something that looks suspicious, don't click on it. Once you've clicked on it, if it's asking for information that you don't think an email would normally ask, don't answer until you've talked with somebody who knows, right? So I'm sorry, there's no simple answer.
Anyone else?
Yeah, and I'll add to that, in the training, don't tell your employee to close it out and get to it later. Act immediately. Go to your IT department, go to your compliance, go to your manager, and act upon that immediately. Don't minimize it. Don't close it out. Just get to somebody that can help you.
Yeah, that quick response, right? We know from experience now that quick response actually minimizes the cost of remediating afterwards. For example, if I see one of these odd emails, and we get them here too, I will immediately notify our help desk, who will then look at our system to see whether others have received the exact same email. And they'll immediately quarantine those emails before anybody opens them. And that kind of quick action saves a lot of money. We did have an attack a couple of years ago where an employee clicked on something. She was doing what she thought was right, and that infection spread through our system. And it cost us a lot of money to remediate that. And had she sort of recognized what was going on, unfortunately she didn't report it as quickly as we would have liked, and that's what helped the spread. Had she reported earlier, we probably would have had a lower cost.
Anyone else?
I'll just, Bob, go ahead.
So Rick, is it even possible to prevent these risks? I just got a letter from the government myself. They lost my data. After being employed for 10 years, they were hacked and lost the data of 20 million federal government employees.
Yeah, I think a lot of us are familiar with that particular incident. An embarrassing day for it was the office of OMB. Yes, OMB. Very, very embarrassing. The answer is, I usually come to these kinds of presentations when I have a longer presentation, and I say, I'm going to tell you right now that if you haven't been attacked, either you don't know it, and you have, or you will be within the next 5 years. And I used to say, come back, I'll buy you a drink. Nobody's ever come back when they haven't been saying they haven't been attacked. So there's no way that I think you can prevent all attacks. The question is, are you prepared to minimize the impact of any attack? Have you isolated your systems appropriately? Is everything broken down? And by the way, once the attack occurs, time's not on your side, right? Because a clock starts ticking on responses and notifications. And if you don't have a plan in place that you've already tested, and had people together who know how to work together, and it's going to include both in-house employees as well as external consultants who you're going to bring in to do forensic work and things like that. If you don't have a team who knows how to work together, it really increases the cost. And I look to the Anthem breach, which a lot of people know about, and I say something was going wrong there. It just took way too long for them to respond, and the costs kept going up because of that.
Rick, is there, as far as insurance to cover this type of risk, are you familiar with what might be available and have any thoughts or suggestions? Yeah,
there are a number of policies that are developing over time. I know Travelers has one. I know Hartford Steam Boiler has one. There are a couple. There are quite a few policies out there, and I don't endorse any particular policy. But one of the things you want to look at is the elements of what the policy covers, and you need to cover not only third-party claims, which frankly aren't going to amount to much these days, because most of the cases get dismissed for lack of proof of damages, but you also want it to help cover remediation costs, response costs. The policies often now come packaged together with some third-party support. So there's a PR expert, a crisis management expert, who's part of the policy. And so they have a panel of crisis management folks you can select from. The breach notification process, it used to be, in the 2000s, they came to us and I did all the breach notification work, right? Our team, could put together a breach notification, but it was fairly expensive. And today there are, companies that's all they do, breach notification. And, frankly, you don't necessarily need me. You need me to look at the letter, but you don't need me to, be putting together the letters and sending them out, right? I like the insurance policies that are coming, well packaged. But I will tell you, do not ask for coverage until you have sort of done your own internal work and know what your status is and how clean you are. Because if they do the underwriting work before you've done your own housekeeping, you'll find the cost of that policy is much higher than you might like.
Which really, just to emphasize that point, the regulators want you to be thinking about this in advance and put in your procedures in advance. The insurance companies want you to be thinking about this in advance. Hopefully nobody will ever have a really bad attack, but everybody needs to have the policies and procedures and the training and the coordination.
And that's whether you outsource all your technology, you outsource some of your technology, or if you have it all in-house. It really doesn't matter, and that's what you were talking about earlier with the vendor management. Just because you outsource it, that doesn't relieve you of the responsibility
Dave?
I just had a further comment, if I may. As long as we're on the insurance theme, you all have on your desk an article that we wrote in September, which deals with the effect of the Yates Memorandum on directors and officers' liability insurance. And essentially the thrust of this article has to do with increased expenses, increased claims, insured versus insured exclusion, and basically just the multiplicity of individual claims that are probably going to come down the line following Yates. I just wanted to make sure you were aware of it and take a copy with you. It's on your desk.
Yeah, and Dave, that raises the important note, right, that not all policies are alike. There's no standard form for what's really called gap filler coverage here, right? There's no standard form. And so you want to study very carefully what the exclusions are. There was recently denial of coverage, which was upheld by the court, where the policy specifically said that the company needed to maintain appropriate data security measures, etc. And they were able to show that the insured did not do that, right? They didn't have appropriate protections in place, and therefore coverage was denied. So you really want to study those the exclusions from the policy very carefully.
I would like to, first of all, thank all of our speakers today. Let's give them a round of applause. And I'd also like to thank all of our attendees for being here. We do this every year. When you leave today,